All right, I think we've got it now. All right, all right. Good morning. So, thank you so much for your patience. Good morning, St. Vincent and the Grenadines once again. Welcome to EFM 99.9's Activated Mornings for today, Thursday, the 11th day of May 2023, 17 minutes after the 8 o'clock hour. It's now time for Cop Chat. And joining us this morning is Miss Letitia Sandy. She's the director of the FIU, Financial Intelligence Unit. We say good morning. Good morning.
Good morning, Crystal.
Lovely, lovely, lovely. It's a pleasure having you on Cop Chat for today, Thursday. So, FIU, big term, big responsibility. What is the FIU?
FIU, it's the Financial Intelligence Unit, and we are the agency in St. Vincent and the Grenadines responsible for investigating and analyzing all matters relating to money laundering, terrorist financing, and other financial crime. We are a hybrid unit, so we have police officers, lawyers, analysts, and an administrative staff. And every entity in St. Vincent and the Grenadines, every financial entity, they're required to file what are called suspicious activity reports with the FIU. So our core function is to analyze those reports when they're filed by these financial and non-financial entities.
Okay, so you said a hybrid unit. Does that also mean that this unit is, I'm not too sure what is meant by that, but is it independent of all the other units? So the police would play a part and the lawyers and so on.
Yes, well, the FIU in St. Vincent and the Grenadines is one of many found around the world. These entities are put in place to combat financial crime. So there generally are certain models, those that are only responsible for analyzing suspicious activity reports, those that may just be police in nature, but we have combined the models. So we have legal officers or lawyers who are part of the staff of the FIU. So we're able to prosecute money laundering cases along with the Office of the Director of Public Prosecutions. We also do civil cash forfeiture matters in the magistrates court as well, and civil recovery at the High Court. We have police officers who are seconded to the unit, and while they retain all of their police powers, they, however, are specialized and responsible for the investigation of the financial crimes associated with the FIU. And we, of course, have the financial analysts who would analyze the suspicious activity reports that come in from the entities. We also have a supervisory department, and that department is responsible for overseeing the non-financial businesses and professions, or the non-regulated service providers. And that just means the lawyers, the accountants, the jewelers, the real estate agents. They too are required to comply with the various anti-money laundering, counter-financing of terrorism legislation. So our unit is responsible for ensuring that they comply, as well as the non-profit organizations. So hybrid, meaning that we have merged the various models of financial intelligence units and have them under one house. And one question you asked that's very critical is that we're an independent unit. The hiring, the decisions in respect of the day-to-day running of the unit are all made by the director of the FIU. And while we do liaise with a number of public sector entities and a number of governmental agencies, we operate as an independent autonomous agency. And it's only if there is a particular matter that we, after we've done obtained the relevant court orders, that information is then relayed to another agency. But the work that we do is done in-house, and of course the I in our name is very critical intelligence. So it is not information that is very easily or readily shared with anyone else.
Now, you said financial crime. You mentioned one before, but if you could just expand on what those are, maybe a definition of each.
Right. So the financial crimes we deal with are any offense from which there is a financial benefit. So if you commit any crime and you have benefited, you've received money, you've received assets as a result of committing that crime, it is what is called a predicate offense in St. Vincent and the Grenadines. So we have money laundering. Persons have heard of that. That is, you have committed a crime, but you obviously don't want people to know that you've committed a crime and this is where your money and assets have come from. So you engage in different ways to make your dirty money appear clean. If you have a business, or you find different ways so that the source of those funds is not clear. You have, for example, further afield, not in St. Vincent and the Grenadines, some of these things that would give rise would be if, for example, there's kidnapping. Obviously, if there's kidnapping and a ransom is paid, you committed an offense by kidnapping someone, you receive dirty money. You stole money. So anything, any crime that you commit and you receive a financial benefit for it, be it cash or an asset, it is a predicate offense of money laundering, and those are the types of offenses that we would investigate.
Mm-hmm. I know of terrorist financing that would fall under it
Mhm.
as well. All right.
Yes, yes. In St. Vincent, we have an all crimes approach. So terrorist financing is, while it is an offense by itself, it is also a predicate offense for money laundering because it is an offense from which you can get a financial benefit. In St. Vincent and the Grenadines, we had to do a national risk assessment so that we are applying our resources, our investigative tools accurately. So the
Mhm.
risk of terrorist financing in St. Vincent and the Grenadines is low, and that is based on risk assessments that we've done. But of course, as we all know, that's why we have insurance. You plan in the event that something happens. So we do have investigative powers as it relates to terrorist financing, and all of these offenses, even though they may not be happening in the country, or the risk of them is very low.
Okay. So risk assessment, what is at the top of that list?
Right. Now, the Financial Action Task Force, which is the international standard setting body, that is the body that sets out 40 recommendations. So these are the rules that apply to money laundering, terrorist financing, and every country around the world has to implement them. So a part of that was prior to 2012, you just had to have laws. So they said to criminalize money laundering, criminalize terrorist financing, and a number of things. You just had to pass laws. But as time went on, you realize it wasn't just about passing laws, it was about making sure that these laws were being implemented and implemented effectively. So you had to do a national risk assessment so that each country, it wouldn't just be a one size fits all approach. You would be judged based on your country circumstances. So you did a national risk assessment involving the public and private sector, which allowed you to know what were the risks in your country as it related to money laundering and terrorist financing, and best determine how to combat those risks. So we conducted a risk assessment. We started in 2017. Of course, there came the onset of the COVID-19 pandemic, which delayed the rollout, but we completed in 2020. So that risk assessment found that the main risk that dirty money came from, money laundering, was associated with drug trafficking, and that, as I said before, our risk in respect of terrorist financing was low. So that risk assessment guides both public and private sector entities on how to allocate resources and knowing what particular areas we need to combat.
Okay, so the biggest one there is drug related. In
Yes.
terms of anti-money laundering, how does that affect banking, the banking sector in St. Vincent and the Grenadines, in terms of regulations? We've heard from time and time again, customers or potential customers complain about, oh, we have to fill out this form, we have to give tax
Yes.
ID, we have to do all these things. How does it affect the banking sector?
Yes, well, the anti money laundering laws, counter financing of terrorism laws are there to ensure that we have a financial sector that is viewed internationally as strong. Because traditionally, of course, if you're seeking to get your money into the legitimate economy, make it appear legitimate, you will use the financial institutions, you will try to bank your monies. And the critical thing is you have to know your customer. And in order for the banks to know you and to understand whether or not the money you're depositing with them is legitimate, they have to get some information from you. The example I always use is if a stranger comes up to you on the road and asks you for $10,000, you're not just going to say yes. You're going to at least get their name, find out if they're working, if they could pay you back. And it's the same approach that a bank uses. So how are they going to know if something is suspicious if they don't know you? And the only way to know the customer is to get those identification documents. It's to know if you're working, and if you're working, how much money are you making? So it's just a matter of the entities understanding. And of course, it is a very big risk for them if they are engaged in are found to be complicit or being used for money laundering, if it's a case that they're not fulfilling these policies and getting this information. And that national risk assessment is critical, because what persons need to understand is, if you provide this information to the banks and the non-bank entities, they're able to do an assessment of you and determine if your risk associated with money laundering is high. So it's not every time you have to go into the bank, you have to give 2 pieces of ID or 3 pieces of ID. It's not every time. So if we comply at the outset, it makes our lives better, and it makes that of the financial institution better, because it is important to protect to protect the reputation, of the entity, and that is how we're able to conduct business on an international scale, because of the reputation of our financial institutions.
Okay. So if a financial institution fails to acquire the necessary documentations or information from a potential customer, from a customer, the individual in question, let's just say John Doe, FIU has found that, or the court has found that he is guilty of an offense. Who is liable for not getting or capturing that data? Is it the FIU, or is it the bank itself?
Well, the legislation actually has offenses within it for the entity, not if they don't have that information, because you're supposed to have a compliance program. And that compliance program means that you have these mechanisms in place to capture that information. So if they are found not, they have a record keeping requirement. So if they fail to keep records, that is an offense under the legislation. So they will be guilty of an offense for not keeping records. And worse yet, if it's found that you're complicit, because it could be possible that, let's say, somebody's engaged in a money laundering scheme and they're using somebody within an entity to assist them, you too can be guilty of assisting that person in that money laundering offense. So the financial institutions and non-financial institutions, it's not just about reputation. There are implications, there are legal ramifications if they don't take this information, both based on the basic requirements under the law, as well as them being charged for money laundering as well.
Now, in terms of money laundering, no, we focus a bit on the banking sector, but I know for money laundering, there can be different units or places where the money can be washed, and there are three levels within the money laundering. Now, in terms of the 3 levels, I'd like for you to identify what those are and just expand on them a little bit. I know placement, layering, and integration.
Right. So traditionally, those are the stages. Placement, literally, you get the money into the financial system, which is where our banks come in, which is why it's so important for them to have the information, and they're deemed the front line, because they're the first ones interacting with the customer and this money. So you literally get the money into the financial system. Layering, you are creating all of these different levels to hide the true source of that money. So you put the money in bank A, and then you send some to bank B. You take a loan at bank C, so that if somebody comes looking, it appears that the money we're seeing you with came from that loan. But in reality, you have a loan and you've repaid that money with dirty money. So what you do have is the money from the bank in reality, but you've helped to have that money in the financial system. You've layered it, so it's a number of complex transactions that make it difficult to know the true source. And then the integration, now it comes back into the legitimate economy. You either get the money, as I said, as a loan, you buy a house, you buy land, you buy some asset. So the money is back. So this asset, this money, the benefit is back with you. Now, those were the traditional ways, but now you could skip steps and you go straight to buying assets. So you may not even go through the financial system, which is why we have to regulate, supervise, as well, the non-bank entities. Because let's say you skip the bank altogether in trying to hide your money and make it seem like you got a loan to buy a house. Instead, you take cash and you go to a real estate agent and say to them, I want to buy a piece of land, but don't put it in my name, put it in Crystal's name, right? So you skipped the banking, the placement, and the layering and gone straight to integration, right? And that is why it's critical that the supervision applies to everyone else, because now the real estate agent, when you come to them, should ask for a source of funds. So where is this money coming from? Somebody shouldn't be taking hundreds of thousands of dollars from someone in cash without knowing what the source of funds is. So it's important to close that gap and remember that we may not always have placement, layering, and integration. It can happen in different ways because, of course, those are the traditional ways and everyone realizes that. So criminals are consistently developing and evolving, and it's important to understand that you may not always have all of those traditional stages in trying to identify a money laundering scheme.
Right. So let's talk about the non-banking sector. So the shop in the village, the maybe somebody who's doing rentals, maybe somebody who has a restaurant or a bar, and you mentioned real estate agent. So they have a responsibility, but do they know that they have a responsibility?
Yes, currently under the legislation, we have what are called the non-regulated service provider regulations, and the name is now sort of a misnomer because it's what they were called prior, because they really weren't regulated officially prior to February of this year. So it covers the lawyers, the accountants, the real estate agents, the car dealers, the jewelers, and some others that I may be missing. And we did, prior to the passage of the legislation, we did have about 3 years of consultation leading up to the passage of the legislation. We were training these entities, and that was one of the benefits of us being a hybrid unit, because in the other areas of our work, we were aware of these various entities. So we were able to compile lists, invite people to training. Before the passage of the regulations, we circulated it to the various sectors and had them provide feedback to us. So, and we do a lot of training annually. We publish articles, we publish on our website as well to try to get people to understand, so that even after the passage of the regulations, there was a 3-month grace period within which that they had to register. And of course, given the size of some of these entities, there was a need to extend that period. Letters were written. There were a lot of phone calls. There were a lot of emails to ensure that people understood that they now had this requirement to register with the FIU. And we do have a number of MOUs with other agencies. So they would make us aware of these entities that exist. And we do call them and let them know that there is a requirement based on the activities that they're engaged in, that they should register with the FIU. So as much as possible, we're trying to do outreach with these entities and allow them to register with the FIU.
Okay, so these entities that are registered are now required. You mentioned declare the funds. I know that within the banking sector there's normally a cap, but there are other areas where you can ask for a customer to complete the declaration. Would that be the same thing for these registered entities? Fill out a form and so on, or it's just asking?
Yes. Right. They would have to be documented, because now coming under the general anti-money laundering regime, there is a requirement to keep records, and all of the relevant entities, which are what they're called, are required to keep records. And there are certain basic things that those records should entail. Now, based on the type of business, you may not keep them. So the regulations would spell out what different entities are required to do. Because as I said, it can't be a one-size-fits-all approach. And a lot of these entities are, in fact, sole traders. So they too should, at the very least, have basic customer due diligence information, bioinformation, the relevant IDs, and you should know where the monies that are coming to you have come from. And one of the things we remind entities is that take that basic information so that you have enough that if there's a suspicion, you can make a report to us. We're not asking entities to be investigators and do the entire matter themselves. Just provide us with sufficient information that we can understand what you're saying is amiss or what is suspicious, and then we take it from there and do the rest of the investigation. So you must at least have that basic information. You're required to keep records for 7 years, longer if an investigation has commenced. So they do have those basic record keeping requirements, and it would vary depending on the particular type of business that they're engaged in.
Okay, so what's going to happen now? It's 8:37. We have to take a break, pay some bills, and then we come right back. When we come back, we'll speak about the investigative part of it and the acquisition of assets. All right, let's take a break and come right back for a cup chat for today.
Census 2023, they're counting you, they're counting me. Must be united. Attention Vincentians, the 2023 Population and Housing Census is on. They're counting you, they're counting me. Census Day is June 15th, 2023. The data collection period runs from June 16th to September 15th, 2023. Your cooperation with the enumerators is vital. Do not turn them away. Give truthful information. The information collected will benefit the whole country. Remember, on this we must be united. Stand up and be counted. Stand up and be counted.
I was looking for a cough syrup, looking for a drug to help this pain here in my throat. I needed something fast to help me with my cold. Then I turned around and there you go. I went into the store and I found what I needed when I shouted Super Health.
Super Health Pharmacy. We're located on Grenville Street, formerly Isles Boutique. Come in and check out our wide variety of over-the-counter prescriptions, medications, personal care products, and much more. Take advantage of our free delivery services, blood pressure, sugar, and cholesterol testing. Open Mondays to Thursdays from 8 a.m. to 6:30 p.m. Fridays, 8 a.m. to 5 p.m. Call or WhatsApp us at 497-8737 or 457-8737. Super Health Pharmacy. Your health is our priority.
And I found what I needed when I shouted Super Health.
Not all heroes wear capes. Celebrate her this Mother's Day at Quartz. Save up to 40% off selected furniture, appliances, and electronics. Get free accessories with selected purchases and much more. Shop with Quartz Ready Finance and pay $0 for 30 days. And before you check out, don't forget to add extended warranty with our Quartz Super Shield product, which will protect your purchase for up to 4 years. Celebrate moms with us only at Quartz, bringing value home. Offer ends May 31st, 2023.
Let's get your laundry clean and fresh with the widest range of washing machines and dryers in SVG. At Singer, choose between our West Point and Speed Queen brands with an array of washing machines with payments starting as low as $92 per month. Your laundry room wouldn't be complete without a Whirlpool or Speed Queen electric or gas-operated dryer, saving your energy consumption. Also in stock is our West Point washer-dryer combo for only $136 per month. One machine that does the work of two. No need to change machines, just toss in your laundry and forget about it. Whether your preference in machines is top-loading or front-loading, Whether you want a 9 kilogram or a larger 15 kilogram washer, whether you're looking for a gas or electric dryer, we've got it all at Singer. Visit us today and get the washing machine and dryer that's perfect for you. Singer, your family company.
At Lynch Caribbean, yes, we offer comprehensive insurance solutions and broking. But we're more than an insurance broker. We drill down to your core business strategy. We keep a pulse on risk to keep your operations healthy.
On your mark, get set.
Along the way, helping you to drive competitive advantages. At Lynch Caribbean, we have your back. Contact us today for insurance solutions, strategic risk advisory, and more. Call 453-3300. Email info@lynchcaribbean.com or visit our office in Beachmont, Kingstown. Follow Lynch Caribbean SVG on Facebook, Instagram, and LinkedIn, or visit www.lynchcaribbean.com.
This is 99.9 Radio. Turn it up.
All right, welcome back to Activated Mornings right here on WFM 99.9. Currently, we're live on Facebook and YouTube at WFM 99 SVG. All right, so if you want to take a look, you can head over there if you're moving from your physical radios. All right, so thank you so much for joining us. The WhatsApp number this morning is 457-9994. The number to call is 457-9997. If you have a question or comment this morning, we're speaking with the Financial Intelligence Unit in studio. Virtually in studio, we have Ms. Letitia Sandy. She's the director of the FIU. So we started talking about the mission and vision of the FIU, the fact that it's a hybrid organization, independent of any other organization in SVG. We spoke about some of the financial crimes, and we zoned in a little bit on anti-money laundering, the banking sector, the non-banking sector, and the responsibilities of all those involved. Let's go into the investigative part. Investigations are they all started by the FIU, or can they be started by maybe like a bank? They have suspicion based on activity and they start it off, or is it the police? Who does it?
Okay, so there would be, you highlighted a few of the ways right there, in that when a financial or non-financial institution has a suspicion, and this suspicion is just, it's just that you suspect that based on what you know about the customer, this is not in keeping with their profile, and that there may be some illegality afoot. It's just a suspicion, and as a result, you file that suspicious activity report with the FIU, and we can proceed and commence an investigation there. Now, given that it's a mere suspicion, there are times where it may not go further, that it is found that using our additional powers, that there really is a reason that this person, let's say, may be receiving money or deposited this amount of money, they just did not provide it in full to the entity. And in that case, the matter may be closed. If, however, it is determined that there really is more to go forward to it, it demonstrates there is some illegality there, then the investigation is continued by the Financial Intelligence Unit, because, as I said, we do have police officers in-house who retain all of their police powers. Now, the police, we do have an extremely good working relationship with the police, and persons from time to time do make reports about a number of matters that have a financial element to the Royal St. Vincent and the Grenadines Police Force. And because we are the entity within the state who can access financial records and information like that under the law, they can make a request of us to obtain information in assisting them in their investigations. In that case, we have what is a parallel investigation, meaning that the police will do the investigation of the substantive matter. So if it's some sort of theft, they will continue investigating that matter. And we will work alongside them investigating the financial aspect of it, because you may have a report of someone stealing money, but you need to dig deeper. Have they acquired any other assets as a result of this activity they're engaged in? And what is it a case where, if they do have assets, are they able to legitimately obtain that? So we would do that financial investigation as well, which can also lead to there being money laundering charges along with the charge that the police would lay in respect of that particular offense that was originally reported. So the investigation can be commenced by us if there is a suspicious activity report, or we work along with the Royal St. Vincent and the Grenadines Police Force, as well as there's information that may come to us from regional or international counterparts, and we can do investigations on their behalf as well.
Oh, okay. So in terms of like regional and international, it's not a case where they're going to fly over your heads and do whatever they need to do. It's everybody
Right.
collaborates. Okay.
Yes,
All right.
because in all of these countries, there is a what is called a central authority. And you go through that authority if you have a suspicion of one of these offenses, and you ask the concerned agency in that country to do the investigation. So in St. Vincent and the Grenadines, our central authority is the Honorable Attorney General. So you send a request if it's needed for court purposes, so a mutual legal assistance request that comes to the Honorable Attorney General. He sends it to our office, and we do the relevant requests, we do investigations, process that request on behalf of the country, send it back to him, and he sends it out to them.
Okay. And the same would apply if there's a Vincentian national that needs to be investigated in, for example, Barbados. You will also reach out to
Right.
the relevant authority over
Yes.
there.
Right.
Okay.
Precisely.
Interesting. All right. All right. Now, let's move on a bit from investigations to acquisition of assets. Now, if at the end of an investigation it's found that that individual is guilty of money laundering, how then do you move forward, or what's the criteria for acquiring assets from that individual?
Okay, so there is a civil regime and there's a criminal regime. I'll start with the civil. The civil can first be in respect of cash. We have the power to seize cash that has either come from or has derived from crime. So we have 72 hours within which to do an investigation, and if we think that there's a preliminary basis that demonstrates the money either came from or you intended to use it to commit some crime, we have to prepare an affidavit and go before the chief magistrate. She reviews that affidavit, determines whether, if based on the evidence, she agrees that there is a preliminary case to be continued. So we have up to 3 months to do investigations. After that 3 months, we file what is called a forfeiture, and we go to court. The person is there, they're represented by their lawyer. You bring your evidence to say, well, no, this is the legitimate intent, and our case may be that, no, this is where it came from, that was illegal. And then the magistrate will ultimately make a decision as to whether or not this money is criminal proceeds, that it came from or it was intended for crime. If the magistrate makes that decision, you have 3 months within which to appeal. And if after 3 months you have not appealed, or the appeal is not successful, the money goes into what is called the confiscated assets fund. Now, that is a fund that is separate from the consolidated fund. And that fund is used to go back into fighting crime. It is used for drug awareness, drug rehabilitation. That's where that money goes. If it's a criminal matter, as you said, if you're convicted of money laundering and you do have assets, there is what is called confiscation proceedings, which says you have been convicted of this offense and you have benefited in the sum of $10,000, right? And you have assets and everything that you've acquired. Now, it's up to the person to either pay that $10,000 in satisfaction of that confiscation order, or they can sell the assets that they have. So in the confiscation, we don't actually go and take your assets. It's a case where this is how much you've benefited and you have to satisfy that order. And it's up to you if you're going to use the actual property or you're going to take a loan to pay for it, right? There's also, on the civil side, civil recovery, which is you have not been convicted of a crime, but on a balance of probabilities, we can demonstrate that the assets you have come from crime. So this is at the High Court that you demonstrate that Crystal has a car. Crystal is not working. Crystal committed some offense, and it was the money that she got from committing the offense that she used to buy this car. And that is civil recovery, meaning that the asset is then recovered, but you don't face any jail time in a situation like that. It is just against the property. And of course, because all of these matters are before the court can agree, the court can disagree. So for example, if the magistrate disagrees with us that the cash came from crime, that cash will be returned to the person. And the law says that when we detain cash, it has to be placed into an interest-bearing account so that the person is not worse off for us having seized or detained that cash. So if the magistrate says that money has to be returned, it is returned with interest. So at all times, because we must operate within the confines of the Constitution. The Constitution operates to protect lawful property. We have to ensure, so these are the checks and balances. There's the court, the decision is ultimately theirs. We have to present evidence. You have the opportunity to respond. And if we in civil cash matters and we return cash to you, we have to return it with the interest that has accrued. So those are some of the fail safes that are built into the system.
Okay, so I have two questions. The first of which, the first confiscated account, is that interest bearing?
The confiscated assets fund, yes.
Right.
But when the money goes into the confiscated assets fund, you can't get it back. But the detained fund account, which is where the money goes while proceedings are ongoing, while if the money is forfeited, we're waiting to see if you will appeal at 3 months. That one, if you get it back from there, you will get in. But when it is transferred over into the confiscated assets fund, it's not able to be returned to the individual.
Okay, I think I understand that part. But the thought that ran through my head is, so these are funds that the court has deemed to be derived from criminal activity. It's handed over to the confiscated assets fund, and it is used for the good, essentially, of the people. And interest is applied to that. So the people benefit from criminal activity in a sense?
No, because the people have not engaged in crime. Because at the end of it, the money is not the thing that has run afoul. It is the person who committed an offense with illegal intent or suspected that there was some illegality afoot. The money is legal tender. So the whole point of this is to deprive the criminal of the monies, of the asset. So the issue is, what then do you do with the money?
Right.
Instead, now you take that money and you apply it to go back into fighting crime, because the money itself is not dirty. The money itself is still legal tender, because the persons in the state who are using that money for good are not committing money laundering. We're not committing an offense, and we have no criminal intent where that money is concerned. But something must be done with that money or that asset. And what is done with it is to use it to go back into fighting crime, because the legislation is very clear on how that money can be used, and it can only be used for those set purposes.
Okay. All right, lovely. Yeah. It's 8:55. We have about 5 minutes to wrap things up. My final question this morning is, some people might go as far as acquiring assets through illegal means, but putting them in other person's names.
Yes.
How then is that dealt with? In the entire court proceedings, are they confiscated as well, or?
Yes. I think I used that in one of the examples where I said that you asked me to put the land in your name rather than the person who's actually buying, because the use of third parties is actually one of the main MOs of persons engaged in money laundering. It's a mechanism to distance yourself from the assets. And once it can be proven that you are the one with the ultimate control and ownership of that asset, and that this person is merely a pawn, and it's really for your benefit, those assets too can be recovered. So it's not a case where we're just going to sweep in and say, we assume it's yours and take it. But a case must be made as to why although it is in Crystal's name, we know it really does belong to Letitia. So there will be evidence that I was the one who purchased it. If it's a vehicle, I am paying the insurance. If I am the one who's driving it. So there is evidence that attaches to show that although it is in the name of a third party, it really belongs to this initial person that we may be investigating or who has been convicted of the relevant offense.
Okay. Actually, I do have one more question. I was looking through a document on your website, svgfiu.com, and there's mention of politically exposed person, or PEP. What is the connection between the FIU and the PEP?
Right. So we spoke about the different levels of due diligence. A politically exposed person is somebody who is in a position of authority. So perhaps someone in government. It can be persons who belong to international organizations, members of the judiciary, and different persons who, and that is the name assigned to them. And it's because you have access to public funds. And to ensure that the public is protected at all times, there is a different level of due diligence that may be applied to them. So there are some entities that may view me as a politically exposed person because I am a head of a state-owned organization. And as a result, that would mean I may be subject to enhanced due diligence. So you need 3 pieces of ID from me instead of 2. You may look more closely at my transactions to ensure that they're legitimate and it's not a case where it is any monies that are affiliated with the FIU that I'm using. So the law requires you to pay closer scrutiny to these persons, but it's on a risk-based approach because not everyone who is a PEP may necessarily have access to funds. So you're supposed to do a risk assessment, and some are high risk, some are low risk, some are medium risk. The only ones that are always high risk are international PEPs. So if someone comes into your institution affiliated with from another country, and they're banking with you, they're automatically high risk because you don't know where that money has come from outside of the jurisdiction. But the other PEPs, you're supposed to do a risk assessment, and they can be high, low, or medium. And this applies to close associates and spouses of those persons as well, because of the question you asked just now about using third parties. So if I am a politically exposed person, I am engaged in crime, I'm not necessarily going to put dirty money in my name. I may put it in a child, in a sibling, in a very good friend. So those persons are also automatically deemed politically exposed persons as well.
Okay, so let me get this also for clarification's sake. If you are no longer in active politics, are you still deemed a PEP? It's like PEP forever.
Right, that's a very good question, because that's one of the things. People tend to say a PEP is a PEP is a PEP forever, which is not accurate, because you're supposed to look at the risk that that person has. So if you're no longer in active politics, you're not affiliated with the party in any way, you don't have access to these funds, there's no evidence that you're that close an associate, you should not automatically be deemed high risk. And that is why entities are required to do an ongoing risk assessment, because factors change. So in that way, you come out of office, you're supposed to do an updated risk assessment on them to see if they should still be deemed high risk.
Okay. All right. So it's now 9 o'clock. We have to wrap things up. I want to say thank you so much for taking the time out to join us and sharing some important information concerning the FIU and the money laundering and financial crimes in SVG. To wrap things up, your final thoughts, maybe contact or we can get more information if need be.
Yes. So first off, thank you so much for having us. We're celebrating our 21st anniversary, actually. We celebrated on the 6th of May. Our website is available, as you said, svgfiu.com, our number 451-2070, but that always comes with the caveat that the I in FIU intelligence, we take that very seriously. There's certain information that by law we cannot disclose to the public, but you can seek guidance from us. You can provide relevant information to us. And the closing remark is always that these money laundering and these crimes are crimes built on crimes. that something very bad had to happen for this person to get this dirty money. And the FIU is here to secure the financial system as well as every person in St. Vincent and the Grenadines and abroad. So we look forward to the continued cooperation of both the public and private sector in this venture.
All right. Thank you so much. And you have a wonderful day, Letitia Sandy.
You too.
All right. Thank you. Take care. And that's it for Cup Chat for today. Thank you so much for joining us. There was a call that was coming through, but it's 9 o'clock, so we have to go. All right.